participated in it. We referred to the case of State versus Kurashi and others, 2022, Volume 2, SACR 459 SCA, where the court held that the inadmissible admission of a co-accused leads to the discovery of real evidence, and the court held that the pointing out by the co-accused led to the discovery of the 4 bodies of the deceased in the murder trial. This evidence, said the Supreme Court of Appeal at page 38, stands on a different footing, and the distinction between the real and testimonial evidence looms large. The evidence was held admissible. My Lord, Brigadier Gininda has testified that as a result of the confessions of accused 1 and 2, he arrested accused 3, 4, and 5. And he mentioned that in the possession, in accused 3's possession, a firearm was found that was subsequently linked to the bullet point that was found in the scene. And he also mentioned that the evidence referred to the evidence of Colonel State that established communication between accused. Mano, there's no procedure.
Objection,
Mr. Mnisi, that's not the procedure, please.
No, I'm objecting, Mano. The procedure is I can object at any time unless the court is saying me to sit down and shut me from objecting.
Yeah, I'm shutting you down.
Thank you.
Yeah, that's
Thank you.
My colleague will get full opportunity to respond to what the state is saying.
Yes.
Brigadier, we refer to the evidence of Brigadier Gininda, wherein he testified that as a result of the confessions of accused 1 and 2, eventually he established that there was communication between accused number 5 and 𝐬𝐿𝐫𝐿𝐫 Khumalo, as testified to by Colonel Stein. During the Section 174 application, my Lord, we referred to the case of State versus Kurashi and others, 2022, Volume 2, SACR 459 SCA. Yes, I'm sorry, my Lord, this is the case that we have just referred to. The further case that we wish to refer to is Robiana and others. It's 2009, Volume 1, SACR, where the appellants had cross-examined the accomplice on the contents of a statement he had made. This is what we are trying to do, my Lord, which also implicated them in order to show that he had contradicted what he had said earlier and that he should not be believed. The court held that a blanket ban against the reception of this evidence against the appellants would have led to an incongruity, to claim that the contents of the statement be ignored and not used to confirm the accomplice's credibility after a failed attempt to use the evidence to destroy his credibility would be plainly absurd. And the judge then concluded that the statement should be received under Section 3(1)(c). And the Ratha Jushes endorses this approach and mentions that this is a case where the interests of justice, if one were to allow to take them into account, would favor their admissibility. If the blanket exclusionary rule would, however, make such an inquiry impossible, and might there not be other cases where the interests of justice might be frustrated by a blanket ban? What if, for instance, the co-accused were shown to be a person of the highest credibility? His statement was made under oath in circumstances where the accused had ample opportunity to question him and challenge his evidence, where there existed strong indicia of the reliability of his statement, and where there was no cause to question the fairness of the trial if the evidence were adduced. And we also referred during that occasion in this 174 application to the article by Medoc Watney, 2015 𝐻 855 and 870, where the author says that it is submitted that a more flexible approach in the admissibility of evidence is required, and the discretion of courts in this regard should not be unnecessarily hampered. Greater relations of the rules about hearsay evidence entail and are alive to the inherent dangers involved in its admission. They should therefore be entrusted to decide the admissibility of all forms of hearsay, including extracural admissions by co-accused, and if admitted, what weight to attach to the evidence. We therefore submit, my lord, that the state is within its right to cross-examine Mr. Sibiya on the contents of a confession made by accused number 2.
Yes, Mr. Mnisi, let's hear you then.
No, you have shut me down, my lord.
Oh, no.
You have shut me down.
No, it's your...
No, you have shut me down.
Just wait. When counsel is still addressing the court, you don't stand up like you did.
No, I can object, my lord.
Yeah, maybe
there is no point. There is no law that says objection can be raised at a particular point. At any point where I feel like an injustice is happening, I've got all the right to stand up and object, and then you are shutting me down.
Okay, fine. You want to say something? You can say.
No, you shut me down.
If you don't want to, no problem.
Thank you.
Yes,
You have
Mr.
made a final ruling by shutting me down.
Ramosipidi.
As it pleases the court, my lord, I'm also going to refer to
If you want time, Mr. Ramosipidi, if you want time to research,
yes,
this court is very broad. You can do that.
I can preliminarily do so, my lord. If I'm failing, then I'll request for time.
Look, if you want time,
Yes,
I'll grant you time. If you want to research,
yes.
fine, no problem.
Let me do so, my lord, because I quickly get my arguments from the trial within the trial. Let me get time to prepare
Yes,
and
fine.
comprehensively respond to the submissions by my learned colleague, my lord.
No problem.
Right?
Mr. Ngomalo?
Not this afternoon.
Mr. Ngomalo?
I also request that I be given time, my lord, to prepare.
No problem.
Yes, thank you.
Okay. How long do you need, Mr. Ramosipidi?
My lord, I can be ready tomorrow morning.
Tomorrow morning?
Yes.
Mr. Ngomalo?
I will also be ready tomorrow morning. Thank you.
Mr. Mshololo? Okay, thank you. Are you available, Mr. Baloi, tomorrow?
I'm sorry, my lord.
Hello?
sorry.
You're available tomorrow?
Yes, we are available.
Yeah. Okay, then we shall adjourn until tomorrow.